let's talk about judicial writing, arguably the most important type of legal writing that anyone can do. So the first question is, what is it? Judicial writing is a form of legal writing that settles a dispute between two parties, as opposed to legal writing where a lawyer is just advocating for their client. So who are these judicial writers? Now, of course, there are traditional state and federal trial and appellate judges that everyone should be familiar with. Judicial clerks also often help their judges by drafting judicial writing, so they are judicial writers too. There are also private judicial writers, such as arbitrators and certain types of mediators. But even lawyers and litigants should understand judicial writing concepts. Understanding how judicial writing works can help them figure out how to write and argue in a way that is most helpful to the judicial writer settling their dispute. So let's talk more about judicial writing. The most important thing to remember is it is really important. When people get to the point of going to court and asking a judge to make a decision, it is the end of a story that started long before the case was filed. Indeed, the party's story usually started years or decades before. The story is often one of pain, suffering, and lost hopes and dreams. Parents fighting over the remains of a broken family in a bitter custody dispute. A family losing their home. Someone spending months in the hospital after a serious car crash or botched medical procedure. Now, it's not always this dramatic, but the point is, behind the dry briefs and attorney arguments, an often emotional story has taken place for these parties. The judge's decision will have a profound impact on real people's lives. After the decision is written, it can have profound impacts on the future, shaping how people live their life and shaping how people do business. So, we get the point. Judicial writing is important. How do you do it well? In fact, being a good judicial writer is much tougher than you might think. That is because good judicial authors actually have to be three types of good writer. First, they must have good writing style. Then, they must be great legal writers, just like lawyers. And then on top of that, they must be good judicial writers. So, first, like any other professional writer, judicial authors must have great writing style. They have a wide audience of readers, including the parties, attorneys, and the public. So judicial authors must know the mechanics of good writing. They must know how to communicate with clarity. They must know how to be organized. And they must know how to keep things concise and simple. But their writing must also be sufficiently engaging and readable so that even normal people can read and understand the order or opinion. Judicial writers must also be fantastic legal writers. When a judicial author says a case held something, it hid better. Judicial authors can't just make a good argument about the law. They have to get the law right every time. Similarly, when a judicial author says a fact happened, the evidence better say so. And judicial authors must have impeccable analytical skill in applying the law to facts. Unlike attorneys, judicial authors do not get easy redos. They must get everything right each time. So if a judicial author gets the law wrong, it can mean huge hardships for the parties and the public, who often rely on the judge's mistaken legal conclusions. In other words, it is really tough to unring the bell as a judicial writer. Public, companies, and future judges and lawyers rely on judicial authors to get the law right. They are, in other words, super lawyers. But beyond just being a good writer, beyond being just a generally good legal writer, judicial authors have a number of factors to consider that other writers, legal or not, don't. Indeed, judicial authors have so many policies and factors that could be important at any given time, it can almost be impossible to balance them all. So, for an example, judges have to consider how attorneys and the public will use the language and holding in future cases. Judges have to consider what is fair between the parties before them. Judges have to figure out how to decide legal issues that have never come up in the past. Judges have to maintain, and hopefully increase, the credibility of the legal system. Judges have to make sure they stay consistent, both with their prior decisions and other decisions generally. Judges have to worry about offending the parties, offending the representing attorneys. Judges have to be neutral in the words they use and the way they describe the facts in the law. Judges have to convince the parties and public that the decision they reach is the right one. Judges also often have to educate the parties, lawyers, and the public about how the law works. Judges have to avoid advocating when attorneys, all too frequently, do a poor job. Judicial writers have to consider how their writing will change the law. After all, their language will be used by future parties and lawyers. Judges have to consider whether the losing party will feel like the judge listened to their arguments and interests. So now let's talk a little bit about the judicial writing process. In some ways, it's like the general legal writing lawyers do, but there's some differences. First, you get the parties' papers and read them to figure out what they are fighting over. In trial court, this will usually be the motion, response, and reply. In appellate court, this will be the briefs filed by the parties. Second, you distill what issues actually need to be decided from the various issues raised by the parties. Often parties will bring up a number of facts and arguments that are just totally unrelated to the real legal disputes before the judge. Typically, to figure out what issues need to be addressed, judicial writers will look to the governing legal standard. For an example, the motion to dismiss. Third, you must research the law. During this stage, the judicial writer collects the relevant authority, including cases and statutes. The parties will have often included citations to legal authorities in their paper, but the judicial writer must meticulously ensure the parties correctly got the law right. Next, it can be helpful to draft an outline. Most people agree that detailed outlines are the best, and the judicial writer must figure out how to organize the various sections and how to address all the legal issues raised by the parties. The judicial writer then starts writing a first draft. Often the hardest part of any writing project is getting things down on the page. This is particularly true for judicial writers because of the complexity and moving parts in many disputes. So after the first draft, the judicial writer intensely edits for general style, for legal writing factors such as citations, and by considering the various judicial writing factors we discussed before, such as whether the language is neutral. During this process, the judicial writer will usually consult with law clerks or other judges for input on each stage of the draft, including both style and substance. Then finally, you can celebrate as you publish your opinion in order. Now let's take a quick look at the different types of documents judicial writers draft. There are two broad categories of judicial writing. Trial writing, where the judge or arbiter is settling a dispute between two parties in the first instance in a trial, and appellate writers, who is reviewing a lower court's decision. What goes into the various orders and opinions depends on the specific case in question. Judges also vary substantially in their own unique individual writing styles, but there are some general lines that can be drawn. Where a trial or appellate court is ruling on a simple issue, the issue is of little importance to the case, or the issue involves a well-settled question of law that is easily disposed of. The order or opinion will usually be relatively short, contain few details, and little analysis. Where a trial or appellate court is ruling on important issues to a case, new complex issues that have not been ruled on before, or the case involves high-profile issues that will have big impacts on the future of the law, orders and opinions will usually be more detailed, meticulously analyzed, and include much more law and facts. Finally, let's look at the general structure of judicial writing. Judicial writers take many different approaches to how they structure their documents, and what they include in them. But there are generally a few core sections to any piece of judicial writing. First, most judicial writers begin with an opening paragraph that quickly orients the reader. Most modern judicial writing includes the key facts of the dispute, including the who, what, when, where, and why of the dispute. This way, the public, lawyers, or judges can quickly figure out what the case was about and what the judge decided. Next, there is a facts section that provides a narrative of the facts relevant to the party's dispute. Next, there is the analysis section. In this section, the judicial writer identifies the legal standards or standard of review that govern the case, and then applies these legal standards to the facts to explain which party wins and why. Finally, there is a conclusion that provides resolution to whatever dispute the judge is settling. The conclusion will explain who wins on the motion or appeal, and often will explain what will happen with the case next. For an example, remanding the case from the appellate court to the trial court, or dismissing the case. This should give you a general idea about what it means to be a judicial writer.